Hello, everybody. Good morning, good afternoon,
Morning.
evening.
Morning.
Afternoon.
I want to do the Nigerian protocol, but I don't know how to go about it right now with so many different people around without offending anyone. So if you would please allow me, if I take the permission of the most senior judge in our midst, to observe all protocols in groups, Lords of the Supreme Court of Nigeria, Supreme Court of Uganda. I have not seen, so far, those I see registered already. Courts, justices of the Court of Appeal, judges of the High Court, judges from United States, judges from Liberia, senior lawyers, then senior advocates of Nigeria, judges and lawyers from South Africa. And I just realized somebody from Australia. So any other persons from Australia, professors, learned professors, professors from other interdisciplinary studies. Thank you all. Students, thank you all for logging in. For those of you with different time zones that came in way before time, and someone just kept calling me and saying, oh, waking me up and saying people are already logging in and all that. So, but the time is there, but sometimes it can be confusing, the time difference. So thank you all for logging in. So someone is actually supposed to start and introduce me, but I'm sure he has some technical issues. I hope you can all hear me. So, Courts and Society webinar. My name is Ari Tobiayemo. I am the convener, the initiative. This is like my brainchild. It's a research I've been working on for close to 19 years. Inadvertently, of course, but somehow I had it in the back of my mind intentionally that I wanted to do something about courts, but I didn't know it would end up this way. The theme, before I go on into history, the theme of this webinar, because every year, as we plan to do, we intend to give webinars on different areas of law in different parts of the world. And somehow, having left the West Coast of Africa to the East Coast of the United States of America, I have seen that with all of the difference in culture and personalities, there is no difference in the court system or the law. Somehow, common law, civil law, we are all the same. I have come to understand that, especially as it relates to society and democracy. So for this year, 2022, the theme of the webinar series is the court's influence on development of law and society. And specifically, the first webinar, this Maiden webinar, is titled The Impact of Judicial Precedents on Societal Development. So what is the history? What is this Courts and Society history about? Courts and Society is an initiative of A.T.SOCIO-JUDICIAL Consulting, a firm that was registered last year, November 2021. And that webinar, that symposium, I beg your pardon, my company decided to go on the first of its calling, I would say, or assignment to do conferences and symposiums. So the first of its kind was in honor of my late father, who is an epitome of what I call a relationship between the courts and society in diverse ways, at home, at work, with his janitor, security man, oddlies. He was a man who had two faces in one, and somehow each of his lives had a certain equilibrium to balance what one aspect was to the other. And somehow I saw in him something that made me to see that there is possibility that the courts and the society can have a relationship that can help our democracy. So that company birthed the Nikitobi Symposiums. The first of it was last year in Nigeria, December 2nd, and we had judges from all over tune in, and we had Nigerian justices. I thank all the Supreme Court justices that supported and blessed this wonderful venture. Your blessing has made it really possible and easy. I thank all the learned LCNs. I thank all the judges. I thank my mentors for your wonderful, wonderful support. I specifically want to thank Justice Kanyip. I want to thank my former professor in Benue State University. So straight to how that came about. So when we had the symposium, we had 4 sessions. And from that symposium, it was important that we go on to the next level, because the initiative is about reconciling courts, or the relationship between courts and society. There was a time that people understood and respected the courts and trusted the courts. But like one of my friends said, Dr. Shodikwo, who I also thank, Dr. Bankole Shodikwo, he said, if our courts trusted us and if our society trusted the courts that much and believed in the courts, they wouldn't go and burn down the Bosheri courts, right? And it's true. And then, having traveled this way, I realized that it's not just a Nigerian thing, it's not just an African thing. Even in the United States of America, the society doesn't trust the courts anymore. A professor emeritus of political science said to me, "Oh, that stupid judge." And I looked at him and I tried to explain to him what judges do and how dilemmatic sometimes the role of the judge can be. So those are little things that have contributed to supporting the idea that I've had for so long on courts and society. So we are having this first webinar, this webinar series this year, which will be for the first with judicial precedents and its impact on societal development. The second would be in July, the 21st of July, that would be courts as agents of social change. The third would be in September 9th, that would be the impact of judicial education on the judge, because somehow it's from the experience that I have had, I believe that judicial education is important to judges, to courts, to help understand the society and the role that the courts have in social development. And then the last would be in December 1st, I think, and that would be the role of courts in shaping human rights in a diversified world. So how did this courts and society history start? You would say, and it's funny, but it started in the mind of a little 9-10-year-old in the University of Maiden Primary School, when my father was a professor of law, and I particularly had an encounter with something that happened in the environment, and that shaped my thinking and my interest into wanting to be a lawyer. Although it's controversial among my siblings and I why I read law, my siblings think I was bribed by my father with 11 naira to read law. Although he gave me the money, I keep arguing that it was an incentive. It wasn't a bribe. So in the University of Maiden, my mother had this trade she was doing. It was not in the university specifically. It was a place called Gidadambe in Maiduguri. And there's this young lady, middle-aged, who was stoned to death. And her crime was adultery. So eventually I wrote my first article growing up with that experience on the women and the law. And that article was written before I was 13 or 14, but I kept polishing on it till last year or 2 years ago. And so from University of Maiduguri, that experience took me to the Benue State University, where I so much wanted to read law, but I did not make up the cutoff mark to read law. My JAMB cutoff mark was too low for that. So I went to sociology, and my professor, Dr. Zasha, encouraged me, and Dr. Samba, who was the Dean of Law, then in Benue State University, and said, oh, if you could make it, then maybe you can move from sociology to law, but we cannot admit you to law. And God bless Professor Ayua, who assisted in sustaining the admission. So they admitted me into Benue State University, and I was a sociology student, sociology major. And from sociology, I had to combine law courses, and to God's glory, I made it, and I became a law student. Now that understanding, even though it was a dark moment for me where I had to go about a mile plus to the next campus to meet for lectures, because I was taking law classes as electives and somehow they would clash. So I would leave one class at the end of lectures and go to another. And so it was a daunting time for me, but eventually, years later, I can see that I have established a theory, or propounded a theory that is a marriage between sociology and law, which is what this Courts and Society initiative is all about. From Benue State University, I got involved with SERAC, the Social and Economic Rights Action Center, which is a non-governmental organization that deals with citizens that are deprived of their basic rights. From there, I related with community and got to understand, and I was going to courts on behalf of these people, and I got to understand the importance of the courts in society and how distant the law is from society and the role of the courts therein. Eventually, then I got to University of Lagos, where I did my master's degree and further understood through the help of different professors, late Professor A.D.M.E., God bless his soul, Professor, I've forgotten his name, the many professors in the University of Lagos that assisted in shaping my mind to. Professor Osipitan taught me, I think, 1 or 2 classes, yes. And, you know, I picked up at that time, I started to understand and realize the importance of the role of the courts. Then eventually, the Lagos State Magistracy, where I now I had the opportunity to be now on the bench to relate more with the society and seeing more how society was so afraid of courts and yet not understanding the challenges, other than saying, oh, that judge took a bribe, oh, that judge knows this person, that is why the judge decided to give this decision. That led me to further my studies, the Judicial Studies program, where I met wonderful judges from across the globe, and we interacted on different respects, and we understood that the role of the courts anywhere is the same, but society and courts have a relationship that has to be understood and respected. But more than anything, my father, in his diverse ways, watching TV, eating, cracking jokes, he made me to understand the importance of the role of courts in society. As he would say and reiterate in some of his judgments, the law has a role to play in society. Most of us, his celebrated case in Mojeku against Mojeku, where he talks about culture and the impact of culture in the life of individuals. So thank you very much. We're going straight now into our discussion, and I'll be introducing the keynote speaker. Honorable Justice Agim is a justice of the Supreme Court of Nigeria, a former teacher of jurisprudence and property law at the University of Gambia. He was a professor of law at the West African Insurance Institute, a justice of the Supreme Court of Swaziland, and at different times, the justice of the Court of Appeal in Gambia and the Supreme Court of Gambia. He was also the Chief Justice of Gambia. He reformed the Gambian judiciary in diverse ways. He has decided notable cases that established judicial precedent in Nigeria, which has automatically engineered societal development. His notable decisions in Reverend Jolly Yame against Federal Republic of Nigeria, PDP against Senator Anaken Lokobiri, the chairman of EFCC against AG Federation and others, Gabriel Soswan against Federal Republic of Nigeria, and the case of Idris against government of Kogi State and others are few of the several cases that have significant cases that establish socio-political precedents in Nigeria's polity. He has received several awards in recognition of his devoted efforts in judicial development in Nigeria and other countries. I would call on Milord. I'm thinking maybe I should just go through everybody's, and then I would introduce everybody, and then we'll take it from there instead of taking it one after the other. And the next speaker would be the discussant. The first discussant would be Judge John Larsen, who serves as an administrative law judge from the California Public Utilities Commission, where he has presided since 2020. He has served as an administrative law judge and mediator for the California Department of Insurance, and he has served as a deputy commissioner for the California Board of Parole. He obtained a Bachelor of Science degree in mechanical engineering from University of California, Berkeley, a Juris Doctorate, that's equivalent to our law school law degree, LLB, degree from Santa Clara University School of Law, and a Master's in Judicial Studies from the University of Nevada, Reno, and the Judicial Studies Program of the National Judicial College, where he's also lectured as an instructor for the Judicial Studies Program. Distinguished Professor Taiwo Osipitan, the next discussant, learned senior advocate of Nigeria, is an alumnus of University of Lagos and the London School of Economics and Political Science. He was appointed a professor of public law in 1998 and a senior advocate of Nigeria in 2012. This University of Lagos conferred him the Distinguished Professor of Law for his dedicated service to the development of law and jurisprudence, making him the first and only one to hold this title in the university. Professor Osipitan has several presentations and publications on judicial precedents, and these publications are unprecedented. I particularly used a couple for my dissertation that were very insightful in the mind of the court and the mind of counsel in judicial precedents. Professor Osipitan served on several state and national fora, including preparing the 1999 Constitution of Nigeria. Incidentally, constitutional law and jurisprudence are his passion areas. He is the editor-in-chief of the monthly judgment of the Supreme Court Law Report and also the managing partner of Bayo Osipitan & Co. He chairs the University of Lagos Consultancy Services. And to celebrate South Africa's judicial jurisprudence is Advocate Sibonile Khoza, who is a member of the Cape Town Bar and Johannesburg Society of Advocates. He acted as Chief Director, Head of Policy in the Policy and Strategy Unit under the Western Cape government. Advocate Khoza was a coordinator and senior researcher in the Community Law Center, now Dula Omar Institute. He was editor-in-chief of the Economic Social Rights Review, ESR, review publication and the Socio-Economic Rights Manual. Advocate Khoza published chapters of articles in several books and journals, presented at national and international conferences, and provided seasonal lectures and conducted advocacy work for law and policy reform on issues of socioeconomic rights and constitutional human rights law. He has consulted for national and international institutions, including Medical Research Council and the World Bank. Khoza obtained both LLB and LLM degrees from the University of Natal, Durban, and obtained a postgraduate diploma in development policy and practice at the University of Cape Town. So these are all the presenters for today. We are ready to hear from Milord. Milord, sir. Thank you.
Thank you, Dr. Toby. I'm happy to know that Professor Kanyip, President, Industrial Court, and my colleague and very eminent and distinguished Justice of the Supreme Court, Justice Helen Morekenyi-Ogwumiju is here. I have gained one thing today. During your introduction of the very distinguished and eminent Professor Osipitan, I have learned today that he's one of those who produced the 1999 Constitution. In future, I will discuss that with him again. But let me leave it at that here. You are all welcome. I thank God for enabling us to have this session. I pray that I will make some sense in my presentation. I have been warned that I will speak for, is it 25 minutes? Did you say so, Dr. Toby?
Yes, sir.
So that will inform my delivery. The topic I will speak on is on the impact of stare decisis on the development of society. Stare decisis, a Latin phrase which in English language means stand by the things decided, is the legal principle or rule that requires that issues in cases before courts be determined on the basis of adherence to judicial precedents in previous cases involving similar issues and basically similar facts or circumstances. The substance of this principle is that similar facts and issues in the precedent cases be decided similarly in the recent case, stare rationibus decidendi, keeping to the ratio decidendi of past cases, in bracket, and stare decisis et non quieta movere, standing by things decided and not disturbing settled points. These are the principles that are inherent in that concept. It is the ratio, decidendi, or reasons for the decision that constitutes the precedent that must be adhered to. This principle is a common law method of administration of law and justice that is part of the English law Nigeria first judicially adopted and later statutorily received as part of English law as a colony of Britain. Today, it is constitutionally entrenched in Nigeria as the principal method of administration of law and justice by Section 287 of the Constitution of the Federal Republic of Nigeria, 1999, which provides, I quote, sub 1, the decisions of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Supreme Court. Subsection 2, the decisions of the Court of Appeal shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Court of Appeal. Subsection 3, the decisions of the Federal High Court, the National Industrial Court, a High Court, and of all other courts established by this Constitution shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Federal High Court, the National Industrial Court, a High Court, and those other courts respectively. The courts have acknowledged this provision as establishing the adherence to judicial precedent as a constitutional policy or principle. In Chief Jude Okeke versus Abga and others, decision of the Supreme Court of 14th October 2021, the Supreme Court held, I quote, repeated restatements of a law in several precedents from the Apex Court result to the law being so well established that it enjoys definitional precision and is no longer open to question or dispute until there's a change in the law by a clear departure or legislation. The first precedent acquires more respect and permanence as a legal doctrine with its repeated restatements. All authorities, including the courts, and all persons, including legal practitioners, are bound to follow precedents and settle law by virtue of Section 287 sub 1 of the Constitution of the Federal Republic of Nigeria, which provides, I've already quoted, let me not reproduce that part. The legal practitioner that filed a suit number JDO 22-2021 in contravention of settled law and Section 287 sub 1 of the 1999 Constitution engaged in unethical practice. the learned trial judge of Jigawa State High Court that admitted and tried such a suit in disregard of the settled law by the decisions of this court and section 287 sub 1 of the 1999 Constitution engaged in judicial misconduct consequent upon the violation of his judicial oath to serve, observe to several authorities of our courts that establish this principle. In Nigeria, the principle operates as follows. All courts in Nigeria are bound to follow the decisions of the Supreme Court as the final court. I've referred to the authority, Nigerian Supreme Court, where two or more decisions of the Supreme Court conflict, all courts must follow the latest decision. Since the Supreme Court has the inherent power to overrule itself, the latest decision is deemed to have overruled or departed from the earlier one. Refer to decisions of this court on that. The Supreme Court, in the determination of issues in cases before it, is bound to follow its previous decisions on similar issues arising from basically similar material facts, and can only depart from such previous decisions where it is satisfied that the decision was erroneous or was reached per incuriam or will occasion injustice on the principle that it is better to admit an error than to persevere in the error. I referred to several decisions of the Supreme Court on that. The Court of Appeal is bound to follow its previous decisions on similar issues arising from basically similar material facts and can only depart from such previous decisions where two or more of such decisions conflict on an issue, in which case it can now choose which to follow, or where, though the decision is not expressly overruled, cannot stand with a decision of the Supreme Court on the point, where it is satisfied that the decision was erroneous or was reached per incuriam or will occasion injustice. I referred to two Supreme Court decisions out of a gamut on that. The High Court and courts of coordinate status are not bound to follow their previous decisions on similar facts and issues. But the established judicial practice is that such decisions have very compelling persuasive influence, and a judge of a high court or a court of equal status is bound to give good reasons for not following his previous decisions or that of another judge on the same issues and facts because of the need to ensure consistency, uniformity, and certainty of the law, and the mandatory requirement of reasonableness in decision-making. The Nigerian experience in the use of this method of administration of law and justice has confirmed that it follows the statutorily and constitutionally established hierarchy of courts, guarantees for consistency in the application of law, delivery of justice in similar circumstances, and consistent determination of similar cases similarly. There is increased certainty and predictability of what law should apply in a given situation and how it should be applied. The consistency of application of law in similar cases have resulted in a large measure of uniform application of law in similar situations. It has shown that it is not an inflexible or rigid rule, as it allows courts of coordinate jurisdiction to depart from their previous decisions that were made per incuriam, in that they were made contrary to law or where continuous adherence to them would cause injustice, hardship, absurdity, impracticability, and by this generates measured and useful changes in the application of law and even the law itself. Now, having stated all this, I now come to the crux of the matter. How does the principle impact on society? Beyond ensuring consistency of and uniformity of application of law and certainty in the content of law applicable, it is difficult to measure its own direct impact on society, on the development of society. its impact on the development of society can only be measured by how it helps the law function and realize its general and specific objectives and relevance on society. The general objectives of law include to create the rule of law in society to protect public interests, welfare, order and security, to create rights, obligations, and responsibilities, to protect individual rights and freedoms, to ensure equal opportunities, to maintain order, to provide orderly, peaceful dispute resolution processes, to define and regulate social relations, to protect persons and the society, to reflect the aspiration and expectation of society, to preserve the existing social order, and introduce social change when the need arises, to authorize public appropriation of public funds and for public expenditure, to provide a legal framework for the development of society, to define and allocate official authority, define limits of power and authority. Those are the general objectives of law, some of them. Contemporary experiences have continued to expand these objectives, but let me limit myself to this for now. The law relating to particular areas of life in society have specific objectives to attain in regulating each of those areas. The primary objective of judicial application of law is to realize the objective of that law. There are areas of law like contract law, trust law, equity, company law, petroleum law, environmental law, and all the laws. And in those areas, in each area, the law has a specific objective to attain. The primary objective of application of judicial application of law is to realize both objectives, the general objective of law and the specific objective of law in that area. Nigeria is ruled by law, but the law as contained in the Constitution of the Federal Republic of Nigeria, 1999, the statutes and other laws cannot rule the society unless applied and enforced by the courts. Adherence to judicial precedents has made more effective the application and enforcement of law, and thereby strengthened the rule of law in Nigeria, and made the judiciary appear more organized and stable. Courts, institutions, and authorities, including law enforcement agencies, are well guided by the judicial precedents on the likely consequences of any act, omission, or situation. The consistency and uniformity of application of law and the certainty in the applicable law has increased public confidence in the judiciary. The adherence to judicial precedent has forced respect for the sovereignty. I use the word forced deliberately. Has forced respect for the sovereignty of the people and has caused an increasing developing habit of obedience of law, observance of fundamental rights, child rights, rights to equal opportunities, political rights. The consistency and uniformity of application of law and the certainty of the applicable law has increased foreign trade and investment and transactions in Nigeria. Adherence to judicial precedent in election cases is largely responsible for the developing culture of free and transparent election, compliance with election laws, transparent political party primaries to nominate candidates for general elections, far-reaching amendments of the Electoral Act to ensure orderly and transparent election. When it came to political parties, I deliberately refused to use the phrase internal democracy of the parties. I deliberately did that because our law is not concerned with how the parties run their internal affairs. The law created a narrow window for the courts to intervene, to control what the parties do concerning their internal affairs. And that has to do purely with nomination of candidates for elections during their primaries. There are elaborate provisions on how the parties should comply with the national constitution, the Electoral Act, the party constitutions and guidelines on their internal elections. And that is why I had to deliberately limit the scope of that impact. There have been attempts by some courts to give themselves jurisdiction that don't possess. Anyway, let's leave that for another day. Adherence to judicial precedents has forced increased respect for the Constitution. Again, I use the word deliberately, forced, has forced increased respect for the Constitution, deepened democratic governance and accountability in public governance. It is responsible for the effective administration of criminal law and justice in Nigeria, and the many amendments to improve application of criminal law are responses to the adherence to judicial precedents in criminal cases. I have decided to elaborate on each of these, but the time allotted to me cannot accommodate it. I will try and make the paper available to Dr. Toby to show how this has specific cases illustrating those points. But this is the general framework of my paper so that it can elicit the questions and commentaries that you said we should allow time for. Thank you very much.
Thank you, my lord. Thank you so much. So we'll just go straight to Judge John Larsen. As you know, we know that judicial precedents in the American society, we can see the various respects. It's on issues of politics, on issues of health, like my lord has said. But in American society, it may not necessarily be in the same aspect or social dimension as the Nigerian culture, judicial culture. But we also know that with the Roe versus Wade situation in the American judiciary right now, the controversy that has been on since 1970s, we can see that there is a situation of society asking the courts to do something. The Roe versus Wade status quo came in after a decision by the Supreme Court, I think, about U.S. versus U.S.A, a case about Washington, D.C. abortion law, and the Supreme Court had reserved their decision in Roe versus Wade for that.
I'll get right to that.
Oh, okay. So basically, he wants to take the floor already. So I wanted to give some of our participants, because I'm also very sensitive that participants are not just lawyers. They are society members. They are people from other careers and professions. So I wanted to give them a background, but Judge Larsen is ready to go. So I will just give him the floor. Thank you.
Okay, thank you, Dr. Toby. I'm honored to be here from California through the magic of this technology as part of this international discussion. And I would like to jump right into it by discussing three precedents, including Roe versus Wade, that I would like to use to stimulate some discussion. But in addition to Roe versus Wade, which is one of the most controversial decisions in the US, or precedents, I would like to start with one of the oldest and then end with one of the newest. So starting from the beginning, judicial precedents have been critical to the development of the United States, as many of you know. But let me give you some specifics that remain relevant today. In 1803, the US Supreme Court established the principle of judicial review in the United States in the case of Marbury versus Madison. This decision meant that American courts have the power to strike down laws and statutes that they find to violate the United States Constitution. The court's landmark decision helped define the boundary between the separate branches of the federal government. In addition to establishing this principle, this landmark decision helped resolve a dispute between the appointments of the outgoing president, John Adams, second president, and whether those appointments would be honored as legally valid by a new president, which was Thomas Jefferson. Now, for many years in the US, we took it for granted that transitions of power took place from one president to another in a peaceful, harmonious manner. But as we all have witnessed, we cannot take that for granted. And Justice Agim mentioned election cases, so I want to bring up the fact that during the 2020 presidential election, we saw the most heavily litigated election in modern US history. And many people expect the next election to be heavily litigated as well. As a result, the US courts play a critical role in upholding the precedents that uphold the very cornerstone of democracy, which is the rule of law and the peaceful transitions of power. But these precedents also have to be, as I believe Justice Agim referred to, limited in scope and impact. Marbury versus Madison, again, it struck down an act of Congress for exceeding jurisdiction. Ironically, the principle of judicial review established by Marbury versus Madison was not in the Constitution, but it became respected and became the law of the land. That is not the case of arguably the most controversial case in the US in the last 50 years, which is Roe versus Wade. Regardless of what our opinions are about women's rights to an abortion, I think it's instructive to look at all the reasons Roe versus Wade has been controversial in the last 50 years. Maybe not all of them, but its controversy is a symbol for part of what divides people today in the United States and encompasses differences of opinion on social and cultural issues. It is also controversial in terms of its judicial policy making. Judges don't like to admit that courts make policy, but most courts, because most courts don't, especially at the lower levels. But at the highest levels of appeal, the fact is judges do make policy. Judges seek to minimize the impact of their policy preferences, but where or when litigants present cases in the absence of clear law, judges sometimes make policy. So here's a couple of the controversial aspects of Roe versus Wade, aside from the social and cultural issues. One is that the court found a right to privacy established in previous precedents that included the right to abortion. Secondly, the court did not just find the state law from Texas to be unconstitutional. That law had made performing an abortion to be illegal. However, the court didn't stop there. It then established a policy regarding when a fetus was considered to be viable, which was after the first trimester of pregnancy. And even scholars in San Francisco have written that that policy established regarding the viability of the fetus was not based on sound science, solid or long-standing science. A good book on that I recommend is this one here, Legal Alchemy by, you can't really see it on the computer very well, by Professor Fagman. So let's consider when judicial policy making is effective and when it is not. There is a classic model of policy making which includes 5 basic steps. And they're discussed in another book that I can recommend called Judicial Policy Making in the Modern State by Professors Feely and Rubin. And they outline these classic steps as defining the problem or framing the issue. Then you identify a goal. you develop a range of alternatives for achieving that goal. You select the alternative that seems the most promising, and then you implement your selected alternative. So to get a better understanding of that, let's consider a newer case of judicial policymaking that resolved an issue that was controversial, but has been accepted across the US in just 15 years. And that is a case of a local trial court in California that served as the foundation for legalizing gay marriage in the United States. It is the case of the 2010 case of Perry versus Governor Schwarzenegger. And it has stood the test of time by laying the foundation for deciding this issue throughout the United States. So let's look at each of these decisions and a few of the aspects that stand out. First, in the gay marriage case, Judge Vaughn Walker only decided whether a statute was constitutional or not. He ended up saying it was not. And he supported his decision with a well-reasoned analysis of extensive expert testimony in over 130 pages. And this was a trial court. And it's interesting because now I'm all in favor of short decisions, but sometimes it's good to be thorough. And in this case, he wrote over 130 pages, which was over five times longer than the Roe versus Wade decision. But he focused on the primary issue. And he was a trial court judge. He was not on the Supreme Court, where he may have been tempted to say more, as Justice Blackmun did in Roe versus Wade, and which has been controversial for the last 50 years. He also upheld a well-established right, the right to marry, and he basically chronicled the steady extension of that right, including the earlier extensions of the right to marry in the United States, the right to marry someone of a different race in the case of Loving versus Virginia, which, by the way, was also turned into a good movie. Justice Blackmun was confronted with deciding whether it was constitutional to make it a crime to perform an abortion. And like in the marriage rights case, the Supreme Court determined that Texas statute was unconstitutional. But perhaps the court went a little too far. It created a three-stage framework for reviewing other statutes from other states based on some statistical evidence regarding the viability of a fetus and the mortality rate of pregnant mothers based on a variety of evidence. That part was later dropped or overturned. So there was a precedent that has been, so here we have a case of a precedent that has been modified. And as we've all maybe been following, many justices are considering modifying again. And so this is a case of a 50-year precedent that maybe the judges are about to decide was wrongly decided in some respect, maybe not in all respects. So in summary, I think there are some lessons here for all judges in all countries. And I think Justice Agim alluded to this, that you want to limit the issues you decide. At the higher levels, you can let cases bubble up as they let the lower courts do the work. Or if you were in the lower courts like me, a trial judge, build a good record for the higher courts to use and decide the case thoroughly. I have an experience from the last agency I worked for, the Department of Insurance, where there was a case that was controversial. We had a trial of a couple of weeks. And we knew it was everybody knew it was going to be appealed. So the most important thing was to decide the case with a good record and thoroughly. Eventually did go on appeal on one of the biggest issues. It went up to the Supreme Court of California. It was an issue of finances. It's the State Farm, it's the Jones versus State Farm General Insurance case. And it was overturned. Part of it was overturned by the California Supreme Court. But there was a record and to thoroughly decide the issue, and all the procedural motions were upheld, but the biggest issue was changed. The outcome was changed. So we also want to build on previous precedents, which is what happened in the case of the gay marriage case in California. Unlike the Roe versus Wade case, it did not break completely new ground by creating a whole new right in a different context. Something that we also don't hear as much about is applying the rights or good science. And Roe versus Wade was a good example of that in some respects and not so in others. If you read the Roe decision, which is only 20 pages, it's interesting that Justice Blackmun stayed away from the murky issue of when life begins, but he couldn't stay away from deciding the viability of the fetus, which was not well settled science. So in summary, I think Roe versus Wade stands as a cautionary tale of the dangers of possibly overreaching. And this all just brings to mind many books and discussions on judicial policy and jurisprudence that we've had at the National Judicial College in the United States. And so I'd just like to end with, I'll give a plug to the National Judicial College where I met Ari, and throw these cases out for discussion, and look forward to talking about them if people would like to. But I would also love to hear about your cases in other parts of the world. So thank you.
Go ask.
Thank you, Judge Larsen. Thank you so much. Yes, in September, we definitely will be talking more about the Judicial College and education of judicial officers and the impact that that makes on society. And there you would hear testimonies from different judges who have taken the program and are willing to say how it has impacted their judicial work. So we'd go right to the next speaker, my professor, distinguished Professor Osipitan. Thank you, sir.
Thank you. Good morning and good afternoon, wherever we are across jurisdiction. Let me also stand on existing protocol as said by Arik. May I also thank Arik for inviting me. And when she invited me, I did not even allow her to have a change of heart. I quickly grabbed the opportunity, but I didn't tell her why I grabbed the opportunity.
I know why.
Let me just let you into why I grabbed the opportunity. One, apart from being my former student, your dad was a mentor and somebody we held in very high esteem, both in the academia and also in the legal profession. As a young graduate, I had cause to work as a conference assistant during the 6th Commonwealth Law Conference in 1980. I won't ask you, Arik, where you are there, but then we had this conference and we had to vet and edit some of the papers. And I read through all the papers across globe, across jurisdiction. And Justice Toby's paper stood out as one of the best, if not the best. So I look forward to seeing him during the conference. I met him, made sure I shook his hand very well, and told him how inspired I was reading his paper. And I was not disappointed in how he delivered his paper. Secondly, maybe that will also put a caveat to Justice Agim's issues with me, that that constitution, which we operate in Nigeria as a ground law, was authored by a committee which was headed by Justice Toby. And I happen to be a member of the committee, but he chaired the committee. So I can always hide under him in response to, and also caution Justice Agim that in joining issues with me, he will join issues with Justice Toby also. And should allow Justice Toby to just rest in peace without joining issues with me. But then, during the conference, we were faced with two situations. One, to allow the military to continue and look for a perfect constitution, which we are still searching for, or to put in place a constitution which was designed to last for a limited period, believing that the politicians would come down, settle down, and give us our own constitution, which we say, so to say, to be autochthonous. But as it were, we voted in favor of exiting the military, looking for a constitution that will be workable for a period. But here we are for the past 23 years or thereabout, we are still searching for our own constitution. So I think those who authored that constitution should be congratulated for giving us something to work with while we still challenge the politicians to look for what they consider as the ideal constitution. Having said that, may I also say that that constitution also gives judicial powers to the judiciary. That is Section 6. It embraces separation of powers in Section 4, 5, and 6. So we are talking about judicial precedent today because by virtue of Section 6 of the Constitution, that Constitution enables the judges and the courts to decide for us one way or the other. I want to associate myself with all the presentation made by Justice Agim in terms of how do you define judicial precedent? I don't need to go back to that because my Lord has ably set the agenda. Stay where you are. Make sure that like cases are treated alike. Ensure that you don't revisit matters already revisited. It also has its own benefits and demerits in terms of ensuring uniformity in application of the law. In terms of what you do to ensure that there is respect for the law and respect for the legal profession. In terms of speedy disposal of cases, where you have precedent, it becomes easy to key into the precedent and use it to decide one case or the other. But of course, it also has its own drawback in terms of being rigid. It's said that judicial precedent gives precedent to rigidity, ensures that enslaves us by using old and archaic cases to determine new situations. But of course, above all, we also know that there's also raises the issue of controversy on whether judges make laws or merely declare or espouse the law. You will recall the controversy between C.K. Allen that says that judges don't make laws, they just apply the law. Well, of course, radical judges like Lord Denning will tell you that, while we declare the law, if we find that there is no law on a particular issue, we make the law indirectly by stating that that is the law. So if anybody is in doubt whether judges make law or not, I think the lesson from judicial precedent is that judges make laws, and that even a common law are judge-made laws. Judicial precedents are also judge-made laws. So nobody should say that judges don't make laws. Judges make laws. But then now dovetailing into the topic, like I said, I have more or less adopted most of the things said by Justice Agim. But in looking at it very well, we should be looking at it that if judges make laws, then they have a duty to use law as an instrument of social engineering. In other words, judges and lawyers are social engineers. In the sense that whatever laws come out or decisions come out from the courts must be decisions that reflects the values of the society. They must be decisions that move the society forward. And this is where I give kudos to Justice Toby and other justices of Supreme Court in using law and case law to improve on some aspect of our customary law. I have in mind area of customary law, which is one of the sources of Nigerian law. But that law will only apply subject to the repugnancy doctrine. In other words, courts in Nigeria will apply customary law if they are not repugnant to equity, good conscience, and natural justice. It was through judicial precedent that we were able to abolish wife inheritance. In some areas of the country, if a man dies, the wife cannot go out to marry anywhere. He must marry either the younger brother, younger cousin, and so on and so forth, disrespecting the rights of the woman to decide who she wants to marry. But Supreme Court has reversed that. So also cases where female children cannot inherit their father's estates. They were saying that, well, once she gets there, she takes the estate and takes part of it back to her husband's house. But Supreme Court has made us to realize that the way a boy was born is the way a girl was born. And there's no difference between a girl child and a male child. And they have used law to streamline and also remove the discrimination which exists in that area of law. So these are the kind of things that are coming from the courts that make people or citizens to respect the law. In other words, where you have a law that aligns with the aspirations, with the development in society, then there will be respect for the courts, for the judicial system, and for all concerned. But that's not to say that all is well with the judiciary. The judges have decisions in Nigeria that are conflicting, that are irreconcilable. But then they are bound to make mistakes because they are human beings. They are mortals like you and I. They cannot lay claim to perfection. But when those mistakes are becoming too many mistakes, then there is likelihood of movement from respect to disrespect and disdain for the judiciary. So we need to see how much of this we can eliminate or minimize in terms of for you to do that successfully, for judicial precedent to also operate very well, there are two pillars which I've identified. One is efficient, effective law reporting system, and also affordable law reports. Today we have law reports printed, social in terms of electronic law reports, and also those in hard copies. We do not have a law reporting council like you have in England and other jurisdictions, where they try to look at what law reporters are doing and tell them that, look, some of these things you are presenting as ratio decidendi are not real ratio decidendi. If you look at some of the electronic law reports, even the non-electronic, the hard copies, I always tell my juniors that, look, it could give you a lead, but you must read the law reports in full, because more often than not, what is coming out as ratio from the law reporters are just either obiter or issues that are not relevant. In a case, you have 20 or more ratio decidendi. And some people are citing it, And it's a matter of garbage in, garbage out. If it's cited and the judge is hardworking, he will pick it up. But if it's not hardworking or is pressed for time, he would use it as a ratio decidendi, and the error goes on and on. So first of all, we need effective, efficient, and also affordable law reporting system, and a regulated one that the law reporters are from time to time told where they have gone wrong. Again, happily, we also require a properly structured court system. In Nigeria, we do not have that problem. Supreme Court stands there as the apex court, followed by Court of Appeal, followed by High Court of States, Federal Industrial Court, then Sharia Court of Appeal, and Customary Court of Appeal. And you must, in the structure, obey and follow decisions of the superior courts, even if you don't agree, even if you believe that it would be injustice for you to apply it, it does not lie in the mouth of a superior, of a judge of a high court to say that a decision of the Supreme Court was reached par incuriam. I believe such a judge will obviously cultivate the wrath of the Supreme Court, and is likely to be seen either as an act of judicial rascality or judicial impertinence. So in Nigeria, we ensure that we obey whatever the Supreme Court has said. But again, all is not lost. A clever judge, a brilliant judge would realize that no case will be exactly the same. The facts are not likely to be the same. So if he's able to bring out fundamental differences between that case and a previous case, then he can distinguish that case and refuse to follow it. In other words, a judge who is able to distinguish between the case before him and a previous case by a superior court of record will be able to apply justice according to his own conscience and according to the facts of the case. But again, for us who are teaching law and also practicing, we are seeing so many conflicting decisions. In some courts, particularly courts headed by Justice Kanye, his court is very fortunate. I always told him that that is the only court that the judges, whatever the judges say, may be the final decision, in the sense that you can only appeal against my lord's decision as of right in cases where, in substance and reality, the issues are fundamental rights. Otherwise, in that case, I need leave. So most of the decisions in Federal Court of NIC are final in the sense that they are hardly tested. You need to appeal with leave before you can test it. So what you are likely to have is that you may be having conflicting decisions from that court because of the personal idiosyncrasies of the judges. They might be seeing issues differently. Unfortunately, there's no appellate court to correct such decisions. But as I want to end, I would like to look at how to minimize conflicts in our Court of Appeal and Supreme Court. Between you and I, Supreme Court is biting more than it can chew. It has ceased to be a policy-making court. And appeal to Supreme Court lies on varieties of issues. There's need for us to fine-tune and also limit the appeals that go to Supreme Court. When you limit the appeals that go to Supreme Court, the likelihood is that the Supreme Court will have more time to come out with robust decisions rather than having conflicting decisions here and there. Also, same goes to Court of Appeal. If we can also minimize the appeals going there. How do we do that? Many cases go to the Supreme Court these days because you have people who are appealing, lawyers appealing because they need those cases to become senior advocates of Nigeria. Ari, maybe I just correct you. My inner bar is 2002.
I beg your pardon. Thank you.
2012. So 20 years down the line, I have seen it all.
It was a
So,
typo, I think. I know it was
yes,
2002. I beg
I
your
think
pardon.
it's the fellowship of the arbitrator that is 2012. So I haven't seen it. Many
Thank
of
you,
our
sir.
colleagues are rushing to Supreme Court with frivolous appeals because they need minimum number of appearances to Supreme Court to make the silk. So my suggestion is that you should start, advocacy really takes place in the High Court, not in the Supreme Court, where you just go there and adopt your brief. More of advocacy go into the High Court. So I think you should just reduce the number of appearances required in High Court and Supreme Court, or in Supreme Court and Court of Appeal. And I think with that, the number of appeals would decrease. Again, for those who are still recalcitrant, you need to step up the costs awarded in Supreme Court. By the time somebody is being asked to pay about 10, 15, 20 million as costs, both the litigants and the lawyers would think twice. And in appropriate cases, the lawyers that bring a frivolous case to Supreme Court ought to be asked to pay the cost personally. These are ways of reducing the case docket of the Supreme Court. I also plead that the quality of judgments of Supreme Court and Court of Appeal depend on the quality of advocates that appear before them. In Nigeria, the time is ripe for us to now step up on continued legal education. Lawyers must continue to learn in order to remain learned. It must be compulsory, it must be mandatory that you should embark on continuing legal education. Then judges should be backed up by very, very intelligent and hardworking judicial assistants. Any person who makes less than a second-class upper has no business being a judicial assistant, because they are the ones that will research for the judges and make sure that they get those things right. Above all, our politicians should leave the judiciary alone. They put a lot of pressure on judges. Some judges get appointed based on political consideration and pressure. And when they get there, when cases come before them that affect their sponsors, they're likely to cave in. So we plead with the politicians to leave the judiciary alone and allow judicial officers to do their work without any undue influence. I think these are some of my own suggestions, contributions, and observations. Once again, I thank you for the opportunity to share my thoughts with you. Thank you.
Thank you so much, sir. I apologize again. I think it was a typo error on my part. Thank you so much for the correction.
Thank you.
Well, we'll go next to the next and the last presenter, last but not the least, Advocate Sibonile Khoza.
I must firstly thank you, Ari, for inviting me, but particularly thank you for inviting me to a panel that is quite intimidating for the esteemed panelists you have on the panel. And I am very honored and humbled to have shared the stage with these eminent members of your panel. I thank you for that. And I wish to greet them from South Africa, to greet all of the panelists, and thanks for your input as you have presented before. I have an envious task of having to be the last one and respond to the panelist inputs, but I will take a very different tact. And the paper that I've prepared will be shared with all the panelists, perhaps after this particular session, and whenever Ari so dictates. For the ease of running with the paper, I will not refer to the cases as they are. I'll try and make, because of the audience that is not necessarily South African an audience, I will try and indicate when I'm talking about a different case, but not necessarily to mention what the name of the case is, as that might be confusing. There are quite a couple of cases that I use in the paper, which might be confusing to follow if I were to cite each and every one of them. Now, where I will start is this. I will start with a proposition, and that proposition goes as follows. It says the doctrine of precedent should be disregarded not only when the previous decisions are clearly wrong, but if evidently material changes in society, significant development in jurisprudence, and justice, the interest of justice, dictates. That's the central proposition I want to start with, and I'll tell you why I'm starting with that central proposition. It will become very apparent in my address later. It's a startling proposition, but I will, because of the sentiments that have been presented by my esteemed panelist. The stare decisis rule, as the doctrine of precedent is also known, has been part of South Africa's legal system for more than a century. Imported from English law into our common law, it has been applicable since the days of colonialism and apartheid, and it continues to be applicable in our constitutional democracy. In simple terms, as my colleagues have already mentioned, the stare decisis rule requires a court to stand by its previous decisions unless it is satisfied that ALEC decisions are clearly wrong. The emphasis there is clearly wrong, and not just wrong, but clearly wrong. The significance of the rule is explained eloquently by a former justice, esteemed justice of the Constitutional Court. At the time when he made these comments, he was at the Supreme Court of Appeal, where he said, the doctrine of precedent, which requires courts to follow the decisions of coordinate and higher courts in the judicial hierarchy, is an intrinsic feature of the rule of law, which is in turn foundational to our constitution. Without precedent, there would be no certainty, no predictability, no coherence. The courts would operate in a tangle of unknowledgeable considerations, which all too soon will become vulnerable to whim and fancy. Law will not rule. The operation of precedent and its proper implementation are therefore vital constitutional questions. It is arguably on these bases that the doctrine of precedent has been endorsed as an indispensable value in our current legal system by both the highest court of the land, which is the Constitutional Court, and the second highest court of the land, which is the Supreme Court of Appeal. It is trite that the stare decisis principle operates in the following hierarchical manner in South Africa. All courts are bound by the decision of the Constitutional Court. In the absence of the decision of the Constitutional Court on a given issue, all courts are bound by the decisions of the Supreme Court of Appeal. Both Constitutional Court and the Supreme Court of Appeal may depart from their own precedent, but only under exceptional circumstances to correct their own decisions, which are clearly wrong. The focal point of this address is the judicial power to depart from precedent. I find it problematic, I venture to say, that our courts have adopted a knee-jerk conventional approach to the stringent test of stare decisis, which regards clear wrongfulness as the barrier to and the only ground for deviation. This approach runs the risk of hindering the development of jurisprudence. To be in line with the material changes in society, it also runs the risk of achieving legal certainty at the expense of justice. It is for this reason that I wish to applaud the recent judgment of the Constitutional Court in Bwanya versus Master of the High Court, and this is the only probably judgment I'm going to cite, which was decided in 2021, in which the majority court by Justice Madlanga adopted a flexible and a softened approach to the doctrine of precedent. It overruled its own precedent in a case that it was decided in 2005 by the very same court, the Constitutional Court, in Volks versus Robinson. And you must remember the names that I'm going to use of the cases is going to be Bwanya, which is the most recent judgment, and Volks, which is the precedent judgment. So the Volks was overruled by the Constitutional Court in Bwanya because it was not because it was clearly wrong, but because of the societal development and jurisprudential considerations, which I'll discuss later. Broadly speaking, the recent case, which is the 2021 case, Bwanya case, deals with the evolving concept of a modern family and diverse intimate relationships that have become widely accepted and observed in South Africa, together with the maintenance and inheritance rights that flow from them. More specifically, Bwanya concerns the right of a surviving partner in a heterosexual life partnership who were not married from maintenance and inheritance benefits from her partner's estate. So they were not married, they were partners. The Constitutional Court in the previous case in Volk in 2005 decided that a surviving partner in a permanent heterosexual life partnership who was not married to their partner was not entitled to maintenance from their deceased partner's estate. So when deciding Bwanya, the Constitutional Court's own precedent in Volk was staring it in its face. On the strict operation of the principle of stare decisis, the Constitutional Court was bound by its previous precedent, and that ought to have been that. Unless, of course, it was satisfied that that decision was clearly wrong. And by the way, that decision was a decision of 2005 in the very same court. But in Bwanya, which is the recent judgment, Justice Madlanga took a very groundbreaking move and departed from the doctrine of precedent of 2005. Before discussing what that precedent really looks like, let me just give you a short summary of facts in Bwanya. Bwanya is a Zimbabwean woman who was married to one Anthony Rutch. They had an intimate relationship, but they were never married. They were about to be married before Rutch died in a tragic accident, which was 2 months before they made the trip to Zimbabwe to pay lobola. In his will, Mr. Rutch had nominated his mother as the sole heir of his estate. However, his mother predeceased him in 2013, and he died in 2016, I think it was. Now, Bwanya lodged 2 claims against Mr. Rutch's estate, which is the partner's estate, deceased partner, one for maintenance and the other for inheritance. That claim was rejected by Mr. Volk. Mr. Volks, who was the executor of that estate. And obviously he launched an application to court to have this. And the reason for that, for the rejection, by the way, is that Ms. Bwanya and Mr. Rutch were not married. They were only partners in a lifetime partnership. Obviously, the laws of the country do not, at the time, did not recognize, or rather the laws that she invoked in order to claim maintenance and inheritance did not, or rather excluded people who were not partners. It only included those who were married. Obviously, he rushed to court, to the High Court, to challenge the maintenance legislation, as well as the inheritance legislation on its unconstitutionality insofar as it violated her rights to equality and to marital status, as well as to dignity. The High Court found in her favor insofar as the inheritance legislation is concerned. So in other words, it found in her favor insofar as giving her rights to inheritance. However, it did not find in her favor insofar as declaring the maintenance legislation unconstitutional on the basis that the Volks judgment was binding on the High Court, because the Volks judgment was on the same facts, same legislation, same issues as in Wanya. In Volks, the circumstance was exactly the same. Mrs. Robinson was in a permanent life partnership with one late Mr. Shandling. They were never married. And in the will that he left, he bequeathed some of the assets, some monies to Mrs. Robinson. But Mrs. Robinson lodged a maintenance claim from the executor of the estate, which is Mr. Volks. And that claim was rejected, just like in Wanya, because of the same reasons, because that the act did not recognize partners, it recognized spouses in a marriage. And it only provided maintenance rights to those spouses in those marriages, not partners in a partnership. Again, Mr. Robinson's mounted a challenge to the Constitutional Court on the same ground as Wanya, that the exclusion and differentiation between surviving partners in a lifetime partnership and surviving spouses in marriages violated her right to equality, dignity, and unfairly discriminated on the grounds of marital status. In Volk, Mrs. Robinson succeeded in the High Court, but in the Constitutional Court, the court reversed that decision. So the decision in the Constitutional Court in Volks was that the distinction between married and unmarried people cannot be said to be unfair, considering the rights and obligations attached to marriages that flow automatically by operation of the law. Was no law impose such duty on unmarried partners? And to the extent the maintenance protection to the estate of the deceased person who was not obliged to, during his lifetime, to maintain his partner, amount to imposing a duty after death, which did not exist during his lifetime. The court found that differentiation and discrimination of the survivors or in a lifetime partnership is not unfair. Obviously, in a different judgment, concurring with the majority judgment, there was an additional factor that was considered. That was that the legal consequences of marriage accrue as a result of the exercise of a choice to marry or not to marry. And because heterosexuals have a choice to marry and not to marry, they should live by the choices that they make. If they make the choice not to marry, then they should find a way of defining what rights and duties must flow from that choice, because the rights of the married couples flow by operation of the law. It's already there. Obviously, there were strong dissenting judgments in that judgment of Volk in 2005. There were two judgments. One was by Sachs, Justice Sachs, and the other was by two female justices, Mahoro and Oregon. They were very strong judgments. I say they were strong judgments because they were very lengthy, but also they were very strong, reasoned judgments. Now, let's come back to Wanya then. In disregarding stare decisis, Justice Madlanga, who penned the majority judgment of the Constitutional Court in the 2021 judgment of Wanya, started off by acknowledging the significance of the doctrine of precedent, and that Volks was actually binding on him. However, he unexpectedly and in an about turn elected to disregard the Volks precedent, despite having found it not to be clearly wrong. But here is a twist of the outcome of what he said, which probably will be criticized for years to come. He said, "Much as I'm convinced that the Volks decision was wrong, I am unable to make the jump and conclude that it was clearly wrong. Does this mean I must reach the same conclusion as Volks? I think not," he said. Close quote. Evidently, Justice Madlanga disregarded the stringent test of clear wrongfulness and adopted a flexible and soft approach to the principle of stare decisis. In his explanation of this unconventional and bold move, he departed from the Volk precedent on the basis that a different context exists and significant development in the common law endorsing material changes in society has emerged since the Volk decision was made by the very same court in 2005. In overruling Volks, Justice Madlanga said that he was motivated. He was also motivated by the strong.
Excuse me, can we, sorry, pardon.
Hello, good afternoon. Is your Gara? Okay.
Trying to mute the call. Sorry.
Okay, I'm coming, sir. I'm coming, sir. I'm coming.
I did mute it. I beg your pardon. I'm sorry about that. I did mute it. I don't know what happened. You may go on. Thank you.
Sure. In overruling Volks, Justice Madlanga said that he was fortified by the reasoning of Justice Frontman in a different matter, which was in 2016, in which the Volks precedent was discussed. But in that judgment, Justice Frontman was actually delivering a dissenting judgment, but it was a strong judgment. Now you must add that that's the third judgment that actually strongly criticized the Volks judgment. Now, but that was not in the same judgment as Volk. In that particular judgment, Justice Frontman found, or rather opined, that the Volks precedent was actually clearly wrong. Now, all these dissenting judgments regarded Volk as clearly wrong. And so I was saying that there were dissenting judgments in which post-Volks that discussed Volks, but they also criticized Volks in that they felt that Volks was actually clearly wrong. And one of which was Justice Frontman's judgment in 2016 in another case, which also involved inheritance, in which Volks was discussed. And Frontman was very clear that that judgment was clearly wrong. However, Frontman was a dissenting judgment. It was not, he was not on the majority in that particular case in 2016. Now, all I was saying is this, is that Justice Madlanga in the 2011 case that is under discussion took all of that into account, was persuaded by all of that, but he was not so daring. He did not find the Volks precedent to be wrong or to be clearly wrong. He found it to be wrong, but not clearly wrong, which is the test. The test is much more stringent, is higher. The threshold is much higher than what he decided on. Obviously, there has also been a number of academic authorities that have criticized the Volks judgment over the years. It has never been accepted in South Africa by many in different quarters, with the exception that the stare decisis was in the way as the barrier to ignoring it. Now, let's go back now to the Madlanga reasoning. So he justifies this grand departure from stare decisis on the existence of a different context to the central question in Volks. The central question was this: whether the differentiation between marriages and permanent life partnerships constituted unfair discrimination, whether the differentiation between spouses in a marriage and partners in a life partnership was actually an unfair discrimination. This different context necessitated a reconsideration of two issues which were central to the Volks decision. The first was this: whether there is always a choice to marry, the choice argument. Remember, I said that the Volks was also partly influenced by the idea that heterosexuals have a choice to marry or not to marry, whereas those who are in same-sex life partnerships, who are who want their rights would not have the right to marry, because there is no such thing as marriage of same-sex partners in our law at the time. Now, the second issue is this, is that the notion that the maintenance benefit need only be afforded to surviving spouses, because whilst the marriage existed, the maintenance rights arose by operation of the law. So a man who's married would maintain their wife by operation of the law. The law is clear on that when they are still married. And therefore, that's the reason why, upon death, therefore, a spouse, a wife of the deceased will then inherit or receive maintenance. But that is not the case with partners in a partnership. Now, Madlanga then considered the importance of marriage and family as a social institution in our society. However, he departed with the majority judgment in Vox by saying that he could not comprehend how giving maintenance protection to surviving partners in permanent life partnerships would devalue marriages. He went on to consider the evidence presented to the court in Wanya, this new evidence, which was presented to the Wanya court in 2020, which was not before the court in 2005, and took judicial notice of the development since then. And here's the reality that he considered. 3.2 million South Africans were cohabitating and forming families outside of the institution of marriages. And that number was reportedly increasing. Nuclear family founded solely on marriages has not been a norm in South Africa. Families come in shape and sizes. The definition of family also changes as social practices and traditions evolve. The recognition of the importance of family must not be done to entrench particular forms of family at the expense of the others. These are or were his observations and notes. In light of this plain reality, which was observed by Justice Madlanga, he then stressed that all categories of families are deserving of protection. The reciprocal duty of support, which features in all of them, justifies equal protection, not necessarily in the same way. But the question really must be, how can that equal protection be given in a different way, perhaps, to those who are in lifetime partnerships? The court also acknowledged the significant development in the common law and legislative framework, which has extended maintenance and protection inheritance rights to the similarly situated category of persons, and that is the same-sex partners. So then the question is, why then deprive opposite sex partners the same benefits? On the first issue, the choice argument in Vox, having considered the evidence presented, the new evidence presented in the 2021 case, Justice Madlanga concluded that some opposite sex partners are capable of exercising a choice to marry or not, and some are not. It is not so clear and so obvious that everyone has a choice. For some, many who are vulnerable women, that choice is illusory, is an illusion. Emphasizing the importance of reality in adjudication, the court warned against judges adopting a position of an armchair pontificator who is divorced from reality on the ground. He pointed out that the real question is not whether there is a choice to marry or not, which is a factual question, but whether the institution of permanent life partnership is deserving of constitutional and legal protection, which is a legal question. He endorsed the principle adopted by the Supreme Court of Appeal in a 2016 case, in which that court, the Supreme Court of Appeal, said, if the facts establish a legally enforceable reciprocal duty of support arising out of a relationship akin to marriages, then the answer to the legal question, that is, permanent life partnerships are deserving of protection, the answer to that must be yes, they are. If it is for these reasons that Justice Madlanga found the denial of maintenance benefits to permanent life partners constitute an unfair discrimination, a departure from the vaults.
Now, when a whole governor they address you, my dear. Now when you learn.
My lord, you're sorry, let me mute that. I already muted. But
Justice Madlanga's...
Khoza, if you don't mind, please, if you can, please round up so that we can take a little bit more questions and you would have the opportunity to say your last words after the comments. Please. Thank you.
Indeed, I will try. I'm almost done. Obviously, that was a departure from the Voss judgment. But in summarizing what then will follow as my argument is that what is clear from this particular case is that the Constitutional Court has considered what seems to be out of sync with the jurisprudence that has progressed. So it seems to me that it wasn't only the evidence, the new evidence that was presented to that court, but it was also the observation that the courts in other cases similar to this, dealing with the same kind of issues relating to the same category of people, had actually extended rights to the very same people. And therefore, it felt that in terms of the development of the common law and the case law, the courts had already advanced beyond the Voss precedent. So the Voss precedent was therefore in stark contradiction and a damper to this body of jurisprudence. But it did not do so lightly. Obviously, it did it based on the evidence presented and considering all of the academic as well as the other judgments that criticized the work. In closing then, what Justice Madlanga has effectively done is to change the test and has lowered the threshold of stare decisis or departure from it, from what is termed clear wrongfulness to wrongfulness, which is backed up by evidential reasoning justifying a departure from precedent. This is obviously extraordinary, and for good reasons. Judges rarely depart from precedent of their own, but Justice Madlanga must be commended for swallowing the court's pride and admit that the court was actually wrong in that case. As a parting shot, I submit then that the precedent which perpetuates discriminatory mischief and injustice, as the Volk judgment was, has no place.
Thank you so much.
Ours, and it should not stand.
Very insightful and interesting presentations. Thank you, Honorable Justice Agim. Thank you, Judge John Larsen. Thank you, Distinguished Professor Osipitan. Thank you, Advocate Sibonile Khoza. And we are very excited. Participants are really excited about the insightful comments and intellectual contributions that have been made. We can see that Justice Agim started with the jurisprudential approach of defining and giving us a context to stare decisis, and talked about how the courts are very much impactful in societal development on issues of political change or foreign trades and all of that. But however, I advise that the court should focus on the role, on the position of the court in specifically what the court is supposed to do in respect to the prayers and the cases before them. He has connected the decisions of the case, and he's given his own opinion that if systematically, if anything is having a challenge in terms of the decisions of the court, a prior or a subsequent precedent, obviously the subsequent one, which is closer, that relates more to relevant changes in society, that has taken relevant changes in society into consideration, should be the precedents that should be applied and not the latter one. Judge Larsen, in supporting and reiterating some of the views in the American context, has talked about the Roe versus Wade situation and is talking about courts limiting and maintaining their zones. Has encouraged that judges of lower court should be more detailed in their decisions to give the appellate court avenues to expand or to make precedents based on what they have, as we all know, the decision or the maxim that says you can't put something on nothing. So if you have a decision before a court, the court should be able to say, oh, this is what a trial court has put forward, and the appellate court can work on that to establish precedents that will be impactful to societal development. And Professor Osipitan, in highlighting challenges, in also supporting and reiterating some of what had already been said, highlighted challenges on precedents. Specifically, most interesting for me is the issue of law reporting, because it is in the eyes of the beholder. You give your view based on what you understand, and sometimes how many of the law reporting outlets are like his that specifically employ lawyers or people who really understand the position of the law, or experts in the field, to read through cases and decide what the ratios are or the relevant decisions as the courts have given. And he also went further to make suggestions about the need for judicial independence, specifically saying politicians stay out of the business of the court. And that cuts across all of our jurisdictions, the court systems in all nations, struggling with the level of political influence on the court. And Khoza, Advocate Khoza, in citing the challenges and dilemma, which is the same with every other court, of constitutional courts in South Africa, had given detailed review of the case law and specifically talked about something very interesting that is a research that I have just been working on, researching on, and his issue about the conflicts between personal precedents versus judicial precedents. Most of the times, okay, the court is trying to, it's like he ended with saying that judges hardly depart from their precedents. Now I think a jurisprudence that is fairly new, a jurisprudence by a professor of law from University of Virginia Law School, Richard M. Rhee. And Richard M. Rhee actually introduced coined the idea of personal precedents. And Richard Rhee said that personal precedents, and I quote, says, personal precedent is a judge's presumptive adherence to her own previously expressed views of the law. So in other words, the professor is saying that it is a judge's fidelity to what, this is the decision I decided in the High Court, or the decision I decided in the Appellate Court, and I would stick to it in the Supreme Court. So in leaving the floor for comments, I would want to start with saying, so how does personal precedents, it's a question out there for me as well, how does personal precedent and judicial precedents interact or interfere with the judge's role in impacting its society? So we are going to be taking questions. Thank you all. Are there any questions? Ugochi will be taking this question session. Ms. Ugochi Igala, are you there?
Yes, I'm here.
Okay.
Everybody.
So you can take the questions, please.
I would like to comment.
Yes, my lord. I was hoping that they would take questions and comments would be at the end.
Okay, okay.
Yes, I intend to give 5 minutes for that. Thank you, sir.
Okay.
Ugochi, where are you?
Yes, I'm here. I'm checking the comment section. I haven't seen any questions from anyone yet.
No one has questions? Okay, while we are waiting for their questions, I would want to maybe everybody, Milord will start with his comments, and then we'll take it there in that order. After Milord, then Judge Larsen, and then distinguished Professor Osipitan would, and in that order to Advocate Khoza. Milord, you can go on, sir. Thank you.
Two comments. Number one, on conflicting decisions. What the distinguished professor said in terms of the incidents is correct. It's quite disturbingly rampant. But where we have not sat down to really look at carefully is what are the reasons. A lot of people are a bit too presumptive when it comes to that. And if it is from the lawyers, they never look at it from their own angle. But let me make one point there concerning them. Much of the conflicts are engineered by the ingenious arguments of lawyers and by the refusal of lawyers to observe the rule of settled points, where a point has been judicially settled by several cases or decisions of the Supreme Court over time. It is a fundamental rule of administration of justice that such point is not open to litigation again. But my experience here is that, particularly in political cases, that rule is never observed at all. Settled points are reopened as if no court decision has ever settled them. And you have them coming back again, coming back. And we are forced in some situations to make certain indictments on lawyers who bring up such kind of litigations on settled points. So for me, that is one of the causes of conflicting decision. Like Professor Osipitan rightly observed, if the judex is not very vigilant, he may not notice that this is a settled point. I may go ahead to make a pronouncement which will amount to a differential decision on a point that is already settled by previous decisions, without a mind to overrule them. So if we can observe the rule that settled points are no longer open to litigation, we will reduce it.
Thank you, sir.
Then the issue of on and on litigation, even if there were other courts after Supreme Court, litigation will continue. That one is there. So, but basically, ingenious arguments, you know that this point is settled, you generate all kinds of arguments to generate some kind of outcome. And when there's a pronouncement, you say, oh, there's conflicting decision. There's a settled point, you have refused to follow it. Then let me come to the issue of personal precedent. You have said it is a new area. That is not correct. In judicial practice, there are two dimensions to precedent. One is the personal precedent, which arises from the judex personal vision of what should be the justice of the case in each situation. And that is informed by a lot of factors like his background educationally, socially, and other things. Then there is the judicial precedent, the common one, which represents the law, oftentimes. The position is that since the judge, whatever he does, has sworn to an oath to uphold the law, must make sure that his personal views, however strong they may be, must dovetail into the law as already established. When you now begin to say, I had heard before, even though wrongly, I must continue because it represents my sentiments about certain situations, you may be engaging in an ego trip or some other matter, but certainly not the pursuit of justice. We've had occasion to deal with this many times. There is a starting point, judges' hunch in jurisprudence and other things. But clearly, whatever you do, whatever your personal opinion may be, whatever your sentiments, what is clear is you are to follow the law as established. That's my comment. Thank you very much.
Thank you, sir. Thank you. Thank you for the correction. Distinguished professor, sir. Should we go on with the questions, or while there are two questions, should I go on with that before you?
Yes, you can go on.
Yes, okay.
Are there questions for me?
Okay.
I think it's for everybody. Ugo, you can go on. I think we have one on there. Go ahead.
Directed at anybody in particular. So it says the primary duty of a court is to do justice. What should a court do when this duty conflicts with the principle of stare decisis? What should a court do when the duty to do justice conflicts with the principle of stare decisis?
Well, if the judge is a high court judge or a trial court judge, I think he must bow to the principle of stare decisis. But a way out is for the judge to have what they call case stated to the appellate court for them to decide on that issue. But if the judge feels that his personal views is in conflict with stare decisis, I do not think that judge should allow his personal view to conflict with stare decisis, because this issue of justice, how you feel about the matter, is personal. So the whole idea of stare decisis is to see how you can eliminate arbitrariness on the part of a judge. If each judge decides to do justice according to how he feels, it's an invitation to anarchy and confusion. The whole idea of stare decisis is that you bow to superior authority. But in case you are not able to distinguish it and you feel strongly about it, I think you should do a case reference to the appellate court for the decision to be taken, and also possibly invite them to value themselves on the point. That's my answer to that. But I also want to align with what the views expressed by Justice Agim in terms of reasons for conflicting decisions. That many times we lawyers are also sources of the problem of conflicting decisions. But again, my solution to the problem, particularly political cases, is that lawyers cannot resist pressure from politicians. It's a big problem. And as lawyers, it's time we start thinking more of a larger picture, namely our profession and respect for the profession. The same politician whose pressure you bow to goes out to tell you that lawyers, your profession is inconsistent, you're inconsistent, you're not responsible, and they utter many, many disrespectful words. I've also told my students carefully and my colleagues that as a lawyer in Nigeria, if you're not careful in the next 5 to 10 years, you may not have a profession that you can call law that has respect. We are gradually losing ground, and it is high time we regain the respect. Gone are the days when somebody says he's a lawyer and it's not looking at Nigeria and everybody's bowing and trembling. There's the paradigm shift. And it's time for us to, as stakeholders, to come back and see how we can regain the lost glory. My Lord, my own solution or suggestion is that I happen to have done a case in London. We briefed a solicitor on behalf of an agency in Nigeria. Then they had more or less gotten an order to freeze the account of that government agency, believing that there's no difference between that agency and federal government and government of the federation as a unit. And by the time we filed the papers to show that this agency is separate and distinct from the government of the federation. And there's a difference between government of the federation and federal government. And that money belongs to the federation accounts, not to federal government of Nigeria. They saw the point. And they knew that if the case went on, they would lose and they will pay heavy costs. And they were just saying, look, you know what? We'll take out this case so long as we're not going to pursue them for costs. And we said, no, once you unfreeze the account, we're not going to pursue you for costs. In other words, cost element has been a very, very strong weapon being used against lawyers and litigants in some jurisdictions. I may start recommending that as a way out. Secondly, I believe that it is time also for the NBA, that's Nigerian Bar Association, as well as a bigger parliamentary committee of legislative committee, to start looking seriously into issues or cases where a lawyer who should know that this matter is settled brings that matter to court, believing rightly or wrongly that he will mislead the court or he will get away with the court. So we should not just stop at castigating or indicting such lawyers. Let us put the practicing license of such a lawyer on the table in terms of whether suspend that lawyer or you withdraw his privileges or even strike out his name from the role, all in the name of fidelity to the legal profession. I believe that the profession is larger than any lawyer, so that any lawyer caught in such act of misconduct aimed at misleading the court on a matter that is already settled should be sanctioned. By the time you apply sanctions against one or two untouchable lawyers, I believe people will start behaving themselves. I think that's my own suggestion. Finally, there are so many cases in the high courts that are richer than decisions from some of the appellate courts. Some of the judges of some jurisdictions in the high court are very, very strong in terms of knowledge of the law. I see us citing cases of superior courts and say they are binding on the high courts. But I do not see us citing cases of high courts, so many of them, to superior courts to persuade them. In the spirit of development of the law and other things, those who are in the high court are also closer to the grassroots in terms of proximity and also knowledge of law. Some of them have deep understanding of the law. I also believe that we can grow our judicial precedent by encouraging judgments of lower courts to be cited not as binding precedent, but to persuade their lordships that, this is a way of looking at this issue. So that by the time we are looking at it, there's what we call cross-fertilization of ideas, and our system will be richer for it. I think this is just my own comment. Thank you so much. Thank you.
Okay, our next question is directed at
His
Lordship, my Lord Justice Agim, and he said, the question reads, it's better, my Lord had stated that it's better to admit an error than to persevere in an error. And the question is this: in practice, where an error has been so seen, how easy is it to correct this error, bearing in mind the principle of stare decisis?
Yes, that is why the device of departure from the previous decision of the Supreme Court or the Court of Appeal is put in place. Like Professor Osipitan said, at the High Court may not be in a position to correct that error. So the litigant may have to suffer litigation up to the appellate level to have the opportunity to move the court to depart from that previous decision. My experience is that there are few instances that I've seen lawyers move the Supreme Court to depart from its previous decisions. Some of them argue strenuously, pointing out the injustice, but without really adopting the formal procedure of moving the Supreme Court to depart from that decision. So departure is a device that you use to call the court that please don't allow this error to persist. It will inflict grave injustice on the society. And once the court is satisfied that it is so, it will depart from that decision. I hope that answers your question.
Thank you. Ms. Agala, I don't know if we've lost her. So Judge Larsen, please, your comments now.
Okay. I've noticed from all of this that the practice of law, as Dr. Toby has said, is remarkably similar across borders, especially in these countries that share some common history of jurisprudence. And what I'm getting is there are two challenges that I'm seeing. It sounds to me like maybe the appellate courts are swamped as we are with too many cases. And the challenge is to find procedures that allow you to sort through those cases. And here we have various procedures to dismiss cases early in the proceeding that can be dismissed based on clear precedents. But that's more of a procedural issue. I'm not sure what your procedures are there. And then there's another broader, more common challenge that was raised by Advocate Khoza. And that is, and everyone's talking about this, when and where to follow precedents or depart from some of them. And for that, I think the challenge is in finding clarity in the reasoning. And we have some expressions here that the devil's in the details, and that the clarity emerges when we sort of rise above the weeds and see more clearly what is just and reasonable. And for that is just I think a universal challenge, but I think when judges look at the details through their own humanity, it's easier to see the common human values that emerge from the details, so that you can decide a case in a just and reasonable way. And I think that's probably what Dr. Toby's father embodied, was bringing his human reality, seeing the cases through his reality in a way that finds clarity through the weeds that we all are immersed in the practice of law. And that seems like the universal challenge. And again, thank you for allowing me to be here.
Advocate Khoza, thank you, Judge Larsen. Advocate Khoza, please.
No, I do not have a different view from the honorable judges' views that they've expressed, except to say this, that there's definitely room for use of cost orders against judges, against lawyers that take cases knowing very well what the case is about and go and mislead the court. And misleading the court is the operative term here. But there is also must distinguish that from the case in which a litigant, together with their lawyers, go to court knowing very well that there is precedent, but that precedent they want to challenge. They want to challenge it head on. And that they start challenging it at the very beginning of the case. And I think in that scenario, and to an extent that they have clear reasons and backed up by evidence, as well as justification for challenging it, I think we should be allowed to do so. Otherwise, we're going to block people from having access to courts and having court ventilated in court. And also, you're blocking the development of jurisprudence, but also you're not allowing courts to rethink their own cases. So I think there needs to be a balance in that. But also, nothing stops the High Court, which is the entry point, from making obiter statements, passing statements in relation to what they think about the precedent that is being challenged, when it's challenged directly. If they feel strongly about it, they need to say it. And I think that's part of the exception to the absolutist approach to stare decisis, that you can bring in arguments against the president as long as there's a rational basis for you to depart. The court is allowed to say so. It just cannot depart, but it can make obiter statements, engaging the higher courts to consider them. That's the second point. But the third then is that I think that the absolutist approach to stare decisis is what really becomes difficult, and I think is the subject matter of this discussion of this webinar. And that is that if we are absolutist about it, then certainly there will be no development of the law. It will be hampered, and it would not be brought in line with where the social norms and practices and customs are. And when do we allow that if they mustn't be followed regardless? I think what has been done in South Africa by the recent judgment I spoke about is an example of how it can be done, perhaps. And it is not the only case. There are other cases. I couldn't discuss all of them, but it's an example of how it can be done. But I think the balancing, the stare decisis must be an enabler, must be enabling to develop the law, and develop the law in line with societal values and systems and practices, and depart from those that are old and no longer applicable.
Thank you. Thank you.
Let me say something, some clarifications. First of all, let me point out that the principle of stare decisis has inbuilt mechanism with laid down clear criteria for determining when there should be a departure. It is not a very difficult process. So, because the impression being created is it is some kind of murky water, that there must be some way of finding out. No. Number two, on the issue as to whether if there is a settled position, somebody cannot take out a case to challenge it. We've made it very clear that the principle of stare decisis itself has inbuilt mechanisms for permitting litigants to come with clear, justifiable situations where they feel in good faith and say, look, this is the law, no doubt, but this is where we want to contend. And this is what we are saying. At the lower court, they'll certainly lose the case because the court has no choice, cannot question the precedent. But at the appellate level, they will have the opportunity of invoking these rules of court, permitting you to formally move the court to depart. These are very clear-cut positions. Thank you very much.
Yes. Coach, do you have any more questions?
Yes, we do. We have a question that reads, could Congress help reduce case loads for the courts, at least in future, by passing laws in step with changing societal values? I read again. My question is, could Congress help reduce case loads for the courts, at least in the future, by passing laws in step with changing societal values?
That could probably be for Judge Larsen.
Yes. Yes.
That would be because we don't have a Congress in Nigeria per se, in that the use of the word specifically. So that would be for Judge Larsen.
Well, I think that is possible. That is the job of the legislative branch to limit the jurisdiction of the courts, or to maybe hire more judges, or it could be approached in different ways. If you have a backlog in cases, and I think there are lots of ways to approach it, and one is certainly to look at the jurisdiction, which is maybe should be decided by the legislative branch.
Thank you. Thank you. I am so sorry we are running late on time. I guess if there are no more questions, we can move on to say our thank yous. Any more questions or comments?
Okay, there's a further comment to that question directed at Judge Larsen, and it says there seems to be a lack of political will on the part of Congress to tackle many of these issues, leaving the courts to rely on precedents to decide cases.
Well, I think that is a ongoing universal problem. That's part of the challenge of the legal and judicial profession is to deal with that. I don't have a great answer for that. I'm sorry.
Okay, the last comment.
Okay, we have another comment. I think the option of stating a case for consideration by the appellate court will be the fairest option for a litigator who cannot afford the expense or the delay of waiting for an appeal to be heard.
All right, any responses or comments on that one?
Well, our law prescribes on how and when case should be stated. It may not accommodate all situations where a person wants to challenge an existing precedent. That suggestion is good. Maybe they should amend the law to include such situations.
Thank you. Thank you, sir. Thank you. And the last but not the least, our own teacher, Professor, former DDG of the Nigerian Law School, Professor Ernest Ojukwu, has said in his comment, we have launched an online journal to support the use of precedents and reduce conflicting cases, wrong and per incuriam cases. So he has cited, thank you, sir. Thank you, Professor, Honorable DDG, our own very teacher, for citing. So we'll send it to all participants. He has cited it on the chat box. So if you can't get it, then we'll send it to you. He sent it to www.caselawreview.legal. Thank you so much, sir. I cannot thank everybody enough for this wonderful time that we have had together. So this basically is the first of its kind, and we are hoping that we would have many more of such interesting forums. As we see on the notice, the next would be July 22nd, Courts as Agents of Social Change. We have Honorable Justice Adewale Abib Abiru, Justice of the Court of Appeal. We're trying to diversify. We'll go to the high courts, as we also have heard from our sessions that high court judges have also had very interesting and insightful jurisprudence in precedents and on the law. So we would be visiting the Court of Appeal as much as, and we believe we have the blessings of our big brothers, the Supreme Court, Apex Court of Nigeria, and other appellate and superior courts, that we would go down the ladder in that order to test jurisprudence of different levels of courts. So Honorable Justice Adewale Abiru, JCA, will be giving the keynote on the courts as agents of social change. He's done a lot of work and research on that and presentations. Then we would have Professor Pat Utome giving us his own opinion from a socio-political perspective and a perspective of an economist. We would have Judge Stephanie Petrovich giving us her opinion. She's a judge of the Pennsylvania, in the Georgia in Pennsylvania. And we would have Dr. Johnson Makoba, a Ugandan professor of sociology. And then we'd also have Dr. Sam Amadi, a counsel lawyer from Nigeria. So thank you all so much for your time here with us and for your comments. Thank you again, Honorable Justice Agim. Thank you again, Judge Larsen. Thank you for waking up early. By 5:30 a.m., you were up joining the rest of us. And I totally apologize again to those of you who tuned in because of the time difference and waited for us all along. A lot of people came in and they left because they didn't have the they weren't sure of the time. Thank you again, distinguished Professor Osipitan. Thank you. We always learn from you, and you break down like a classroom. You always break down the points in that order, as giving us, something to think about. And thank you, Advocate Khoza. Thank you so much for giving us an insight of the Constitutional Court. I have actually picked out a research point that I'm hoping that we can work together on the issues of personal versus judicial precedents. I'm hoping that we could do a further research on that. Thank you so much. We celebrate the Nigerian judicial jurisprudence. We celebrate South African judicial jurisprudence. We celebrate the judicial jurisprudence of the United States of America. And we pray that the Lord will keep us all to the next time. Thank you. Bye-bye.